and welcome to Courts Today. I am Urvashi Chauhan with your daily roundup of legal updates from across the country. We will cover important judicial developments across India today, from the NEET-UG 2025 result dispute in the Supreme Court to new Waqf rules notified by the centre. We also talk about updates on the Krishna Janmabhoomi dispute, consumer rights in Dabur versus Patanjali, and the implications of BNSS on anticipatory bail in Uttar Pradesh. Did a single wrong answer in the NEET-UG 2025 exam ruin a student's rank? And could it have been corrected by the Supreme Court? A student took the fight all the way to the top court, but today the bench closed the doors on the challenge. A NEET-UG 2025 candidate, Shivam Gandhi Rena, had filed a writ petition in the Supreme Court challenging the final answer key released by the National Testing Agency. The petitioner alleged that question number 136 of Code 47 had an incorrect answer, and despite raising objections, the NTA did not make any corrections. The student claimed that as per the NCERT class 11th biology textbook, the correct answer to the question on cardiac regulation should have been option 3, that is A, B, C and D, and not what was marked by the NTA. The petitioner argued that a correction would give him 5 extra marks, improving his All India rank of 6783 and general category rank of 3195. He even sought a stay on the counselling process and requested the court to set up an expert committee to review the question. But today, a bench of Justices P.S. Narasimha and R. Madhavan dismissed the plea. The court said that it had already dealt with a similar matter earlier this week and was not inclined to intervene in individual answer disputes in nationwide exam. Justice Narasimha told the petitioner's counsel, Senior Advocate R. Balasubramaniam, that while the student may be correct in principle and multiple answers may be possible, the court cannot afford to interfere at this stage, as it would disrupt the national counselling process. The petitioner's lawyer tried to draw parallels to the 2024 NEET-UG case, where the Supreme Court had directed corrections after discrepancies were confirmed by an IIT Delhi expert panel. But the bench clarified that such interference was allowed only because of the widespread nature of complaints that year, and that this case did not warrant the same. With this, the legal challenge stands closed. The NEET-UG 2025 counselling process will continue as scheduled, and no changes will be made to the final answer key. Coming to an update on a major reform in the management of Waqf properties across India. The Union government has notified new rules that promise digital transparency, accountability, and a centralized tracking system. But will this new framework survive the legal challenge already pending before the Supreme Court? Yesterday, the Union government notified the Unified Waqf Management Empowerment, Efficiency and Development Rules 2025 under the amended Waqf Act. These rules aim to overhaul how Waqf properties are registered, audited and monitored, with a strong emphasis on digital governance. These rules have been brought under Section 108B of the Waqf Act, which was newly inserted by Waqf Amendment Act 2025, in force since April 8th this year. The centre now has the power to frame rules on everything from registration and audit to online portals, and even maintenance, payments for widows, divorced women and orphans from Waqf income. A central highlight is the creation of a dedicated digital portal and database for Waqf properties. Each Waqf and every property under it will be assigned a unique identification number for tracking and reference purposes across states. The Joint Secretary of Minority Affairs Ministry will supervise this digital infrastructure, and each state government must appoint a nodal officer of Joint Secretary rank to coordinate the database and streamline processes like property registration, account keeping and audits. Muttawallis, or the custodians of Waqf properties, are now required to register themselves on the portal using OTP-based authentication and submit full property details through their online accounts. Any wrongful declaration of property as Waqf must be investigated within a year by a government-appointed officer. After surveys are complete, state governments must publish a comprehensive list of Waqfs. The list must be uploaded on the central portal within 90 days of its publication in the official gazette. The rules also lay down procedures for registration of new Waqfs, provision of maintenance keeping of accounts, and annual audits. But even as these wide-ranging reforms roll out, the legality of the Waqf Amendment Act 2025 remains in question. You are aware that the Supreme Court has reserved its verdict on several petitions filings challenging the constitutional validity of the amendment and seeking a stay on its operation. So while the government pushes for modernization and digitalization, the final word may yet come from the Supreme Court. Commercial freedom does not mean freedom to mislead. That is what the Delhi High Court made crystal clear in a major ruling restraining Patanjali from airing ads that allegedly disparage Dabur's Chyawanprash. The decision came in a suit filed by Dabur India claiming that Patanjali Ayurved's advertisements falsely implied Dabur's Chyawanprash was inferior, calling it ordinary and questioning its Ayurvedic authenticity. Justice Mini Pushkarna ruled that the advertisers cannot misuse their right to commercial speech to make false, unverified or misleading claims, especially when the product is a regulated drug like Chyawanprash, which affects consumer health. She noted, and I quote, "What may be allowed as puffery in toilet cleaner ads is not okay for Ayurvedic or medicinal products." The court emphasized that comparative claims in ads for health products must meet a much higher standard because misleading statements in this space can directly affect public health. Specifically, the court restrained Patanjali from using lines such as, "Why settle for ordinary Chyawanprash made with 40 herbs?" and the lines like "जिनको आयुर्वेद और वेदों का ज्ञान नहीं, उनका च्यवनप्राश असली कैसे हो सकता है?" The court found out these statements directly target Dabur, which promotes its product as being made with 40 plus Ayurvedic herbs. The ad was not just comparative but crossed into disparagement, aiming to undermine consumer trust in a competing brand. The court also observed that TV and electronic media have a wide and deep impact influencing consumer behavior at scale. Therefore, courts must examine the overall message of such ads with extra care. In a setback to HDFC Bank's CEO, the Supreme Court today refused to entertain his plea for quashing the FIR filed against him by Leelavati Kirtilal Mehta Medical Trust. A bench of Justices P.S. Narasimha and R. Madhavan made it clear that the Supreme Court would not intervene when Jagdishan's petition is already listed before the Bombay High Court on 14th July. If you recall, CEO Jagdishan had approached the Apex Court citing repeated recusals by the High Court judges in Bombay, which delayed the hearing of his plea to quash the FIR. His counsel, senior advocate Mukul Rohtagi, argued that the FIR was frivolous and part of a private trustee dispute within the Leelavati Trust. Rohtagi said that the bank was being dragged into a family feud and the only intent was to summon the MD and damage the bank's reputation. He pleaded for interim protection from coercive action, stating that the bank was suffering reputationally every day and that he had no involvement in the trustees' internal issues. But the Supreme Court said that while it sympathized with the delays due to judicial recusals, the court cannot interfere when the High Court is already seized of the matter. Justice Narasimha added that such interference at this stage would be improper, though he did acknowledge the unfortunate delays. To ease apprehensions, the bench even added its hope as an observation in the order that the matter be heard on the said date, that is 14th July. The background of this case is that Leelavati Trust has accused Jagdishan of accepting a bribe of 2.05 crore from former trustee Chetan Mehta, allegedly to help him retain control over the trustee's governance. The FIR also claims Jagdishan misused his position at HDFC Bank to interfere in the trust's internal affairs. Can a public prosecutor appointed on a contract demand a permanent post and job security? Well, the Supreme Court says no. The top court has rejected a plea seeking regularization of a contractual prosecutor, holding that there is no statutory or constitutional right to claim such benefit. A bench of Justice Sandeep Mehta and Justice Jayamalla Bagchi upheld the Calcutta High Court's decision, which had refused to grant regularization to a contractual assistant public prosecutor in Purulia in West Bengal. The petitioner had originally been appointed in 2014 by the district magistrate to prosecute state cases in the court of Additional Chief Judicial Magistrate for a fee of 459 rupees per appearance with a maximum of 2 cases per day. Later, he was also assigned duties in another court. But with time, he demanded a hike in the fee and regularization of service, claiming that this was his sole source of livelihood and he deserved equal treatment with regular prosecutors. He first approached the State Administrative Tribunal, which initially allowed his request. But that was later overturned by the state government, and his repeated applications for regularization, job security till retirement and equal pay were ultimately rejected. The High Court also dismissed his plea, saying that this appointment was purely contractual, not made under the structured process prescribed by law, and that he himself had written to continue on a contract basis. After this, the case reached the Supreme Court, where the petitioner tried to argue that his long years of service and poor remuneration justified regularization. But the court held firm. It said that regularization cannot be claimed as a right, especially when statutory procedures for appointment under Section 24 of CRPC, which is now replaced by Section 18 of BNSS, were not followed. The court also noted that when a regular cadre of prosecuting officers exists, appointments must be made from within that cadre unless no suitable person is available. The bench stated clearly that the petitioner had not been able to establish any statutory or constitutional right to deserve the relief of regularization. However, the High Court had earlier granted him liberty to approach the authorities to consider enhancing his fee and directed the government to look into that. The Supreme Court concluded that the special leave petition lacked merit and dismissed it. The Allahabad High Court has dismissed an application seeking to replace the term Shahi Mosque with disputed structure in all the ongoing proceedings related to the Krishna Janmabhoomi suits. A single judge bench of Justice Ram Manohar Narayan Mishra rejected the application, saying that it was being dismissed at this stage. The plea was filed by Advocate Mahendra Pratap Singh and was backed by several other parties in the case. This dispute revolves around the Shahi Mosque in Mathura, which is claimed to have been built during Mughal Emperor Aurangzeb's reign, allegedly after demolishing a temple at what is believed to be Lord Krishna's birthplace. A compromise agreement made in 1968 allowed both temple and the mosque to function side by side. But this agreement is now under legal challenge, with several litigants alleging it was fraudulent and seeking removal of the Shahi Mosque and the right to worship at the disputed site. In 2023, the Allahabad High Court took over 18 such suits, all transferred from the Mathura courts to itself. The Supreme Court has stayed a prior court order allowing a court-commissioned survey of the mosque, and that stay still remains in place. In the current application, the petitioner had urged the court to avoid referring to the site as a mosque while the case is ongoing, suggesting the term disputed structure instead. But the court made it clear that such a substitution will not be entertained at this point in the proceedings. The Krishna Janmabhoomi matter continues to be one of the most sensitive property and faith-based legal battles in the country. In a significant ruling, the Allahabad High Court has held that with the enforcement of Bharatiya Nagrik Suraksha Sanhita, that is the BNSS, from 1st July 2024, the statutory restriction that existed under Section 438(6) of the CRPC, which prohibited anticipatory bail in cases punishable with death or life imprisonment in the state of Uttar Pradesh, no longer holds good. This is a crucial verdict, and it may influence how serious offences are handled going forward. Justice Chandradhari Singh delivered this judgment while allowing anticipatory bail to an applicant, Abdul Hamid, who was summoned in a 2011 murder case despite not being charge-sheeted during the original investigation. Let's quickly break down the facts. Back in 2011, a man was killed over a Zilla Parishad political rivalry. Abdul Hamid was one of the names in the FIR, but police investigations found no solid evidence against him and he was not charge-sheeted. However, in 2019, based on one witness's statement, the trial court summoned him under Section 319 of CRPC, which allows the court to call additional accused during trial. When Hamid filed his first anticipatory bail, it was rejected in 2023 under Section 438(6) of CRPC, a UP state amendment that blocked bail in serious offences. But now, with CRPC repealed and BNSS in effect from 1st July last year, Hamid filed a fresh anticipatory bail application under Section 482 of BNSS. The state opposed it, arguing that the offence happened under the old law and BNSS cannot apply retrospectively. But the court disagreed. The bench said that BNSS does not carry forward the earlier restriction, and this omission was deliberate and not accidental. Parliament consciously chose to remove the bar under Section 438 subsection 6, which had been added by the UP amendment in 2019. The court also held that applicant's circumstances had changed, that his first plea was dismissed only on technical grounds, not merits. A non-bailable warrant had been issued after the dismissal, that he was now 78 years old, suffers from lung failure and has no past criminal record and was never charge-sheeted. Also, that even the post-mortem and eyewitnesses' accounts did not directly name him. Further, the court cited its earlier ruling in Dabur versus State of UP, stating that applications filed after 1st July 2024 must be decided under the new law, which is more liberal and does not have the earlier restrictions. In the end, the anticipatory bail was granted, and the court made it clear that BNSS now governs such applications and UP restriction under the old CRPC no longer applies. This ruling is likely to open doors for many similar bail applications, especially in Uttar Pradesh, where the 2019 amendment had tightened anticipatory bail provisions. Lakshadweep, India's smallest union territory, may soon see a major judicial upgrade. The Kerala High Court has stepped in with a suo motu case, and a comprehensive order is on its way. The Kerala High Court today said that it would soon pass a detailed judgment laying down clear guidelines to improve the judicial infrastructure and access to justice in Lakshadweep. The case is being heard by a special bench of Chief Justice Nitin Jamdar and Justice Ziad Rahmad A, and stems from a suo motu writ petition initiated to tackle long-standing issues with the justice delivery system on the islands. To give you some background, this case originally began as a writ petition filed by a lawyer from Kalpeni Island, highlighting how underdeveloped the judicial facilities were in Lakshadweep. In 2025, the High Court converted that into a suo motu writ petition, and in January, it directed a detailed status report on multiple critical areas, including e-filing, video conferencing, legal aid services, juvenile justice mechanisms, and human resources. Following the court's directions, a joint meeting of stakeholders, including officials from the Judiciary, Administration, NIC, Police, and Public Works Department, was held in March-April this year, and an action plan was submitted with clear timelines. Now, when the case came back up this week, the court was informed that video conferencing infrastructure is fully installed and already being used. E-filing has not yet started, but 2 training sessions for advocates and court staff have been conducted. Progress has also been made on setting up infrastructure for the District Legal Services Authority, and discussions are underway for creating permanent public prosecutor and assistant public prosecutor posts. After a topic-wise discussion, the bench orally observed that it would pass a final order with guidelines on each concern, from internet connectivity to welfare schemes for advocates, from child welfare committees to mental health care centers. The court has now posted the matter for final orders on 1st August. This is a critical step in ensuring that residents of Lakshadweep, despite their geographical isolation, enjoy equal access to a functional, modern justice system.